You've transferred your property into a land trust, great job, but now you're thinking about selling and suddenly no one knows who's supposed to sign, who gets the money, or how to actually prepare the deed. The truth is, land trusts are powerful but misunderstood. And if you don't follow the right steps, your sale could be delayed or even fall through. In this video, I'm walking you through exactly how to remove a property from a land trust the right way, step by step. I'm Ali Talai, estate and asset protection attorney and also founder of Talai Law Offices. I will explain what makes land trusts different from revocable living trust, how control flows through the beneficiary and not the trustee or the grantor, and what documents you need to exit cleanly and confidently. Because the last thing you want is for your trust structure to get in the way of your next big move. All right, so let's talk about what is a land trust and how it is different from a revocable living trust. A land trust is also a revocable trust. However, who has the power to revoke it, who has the power to control it, is different than a normal revocable living trust. In a land trust, we work with a lot of real estate investors, and one of the first things we try to do for them is that we try to create an estate plan that provides them privacy, so that it won't be as easy for a tenant or a creditor having the ability to figure out and find out how many properties they own, what the value is, what the equity is, and where they're located. So privacy planning becomes really essential and one of the first steps in a proper asset protection planning. And in order to do that, land trust can be used as a great tool to provide the privacy that we're looking for. You transfer the property into the land trust, and if it's drafted and the deed recorded correctly, we can remove the owner's name from the deed. And since trusts in general are not recorded anywhere, there is no database that somebody could go in and put a name of a trust and then figure out who created it and who owns it and those sort of things. So it can be used to provide a great deal of privacy for a client that is looking to get privacy. And again, usually it's part of a greater or larger estate plan connected to asset protection planning in most cases. However, if you're thinking about doing asset protection planning, just keep in mind that a land trust by itself, particularly in California, it cannot provide you any asset protection. It's really just one of the layers in the asset protection planning that we do, one of the first steps that you would take. However, let's get into the differences as far as control within a revocable trust and a land trust. First one is control. Who gets to have the control within the trust? In a revocable living trust, the trustee has control. And the trustee can really have great deal of control unless there's some sort of restriction written within the trust. But if there are no restrictions, the trustee can decide to sell a property, to buy a property, and then as far as distribution, again, depending on how the trust is structured, but the trustee really have the main control as far as what gets done within the trust and the asset that the trust owns. When you compare that to a land trust, in a land trust, the beneficiary really has the main control. The trustee will be signing documents if a signature is required on behalf of the trust, but that signature really is being okayed by the beneficiary and the instruction is coming from the beneficiary to the trustee. The trustee has really minimal ability to do certain things within the trust unless it's been okayed by the beneficiary of the trust, which gets us to the second difference, and that is who has the power to revoke the trust. So control in a revocable trust, the trustee has that. In a land trust, the beneficiary has the control, the main control within the trust. As far as revoking the trust, a revocable living trust is revoked by its grantor. So if you create a revocable living trust, you can revoke that trust at any time before you pass away. But the control is with the grantor of the trust. When you compare that to a land trust, the control is with the beneficiary of the trust, not the grantor, not the trustee, as far as revoking the trust, canceling the trust, changing anything within the trust. The beneficiary has the actual power to make any changes to it. And lastly, in a revocable living trust, you usually see beneficiaries as individuals. You create your trust, you name your spouse, you name your children as the beneficiary. You're naming an individual as the beneficiary of the revocable living trust. However, in most cases, when you're now putting a land trust in place, the beneficiary of the land trust is another trust or another entity, another LLC or a partnership. You see that much more often, and a land trust allows the beneficiary to transfer his or her beneficial interest in the trust to another entity, and that characteristic of a land trust realistically provides a lot of flexibility within a land trust. So sometimes I have clients ask me, well, if I'm a beneficiary in a revocable trust, why can't I just assign my beneficial interest in the revocable trust to the LLC or to the next person that I want to assign to? And the reality of it is you could transfer it. However, because in a revocable living trust, the grantor has the power to revoke the trust. Whatever transfer you made to an entity or to another person doesn't really carry a whole lot of weight with it, because that transfer could be undone, could be canceled. And so that's why if you ever are going to transfer something that is owned by that particular revocable living trust, you would take the property out of the trust and have that property transfer to the individual or LLC that you're going to transfer it to. You change the ownership of the underlying asset to the next person instead of assigning your beneficial interest. However, in a land trust, because the trustee cannot revoke the trust, it's only the beneficiary, then in that scenario, the beneficiary of that particular land trust could assign his or her interest in the land trust to the next beneficiary, to the next person that would step in and become the beneficiary of the land trust. And that assignment could actually work because nobody could revoke it. The only person that could revoke it would be the subsequent beneficiary of the trust. And so a lot of times, if we transfer a property into a land trust and subsequently we want to change the beneficial interest of that trust, we just make an assignment and have the assignment indicate the new beneficiary of the trust. So the three main differences between a revocable trust and a land trust is that in a land trust, the beneficiary is the main person that controls the trust. The beneficiary is the person that revokes the trust or has the power to revoke the trust. And also in a land trust, you could name another LLC or another entity or a trust as the beneficiary of that particular land trust. All right, so now let's talk about how do you remove a property from a land trust. You created the land trust, you purchased the property under the name of the land trust, so now the owner of that particular property is the land trust. Now you decided to sell this particular property, maybe it's a 1031 exchange or just a regular sale, it really doesn't matter for this video, but you're going to sell the property, so we need to transfer the property out of the land trust to the new owner. In a land trust, the beneficiary has the power to remove a property out of a trust. The trustee cannot unilaterally just sign documents on behalf of the trust. So if we are going to remove a property out of the land trust before the trustee actually signs anything, the trustee needs to get a written direction from the beneficiary of the trust. This is a written document that is signed and notarized by the beneficiary that instructs the trustee to transfer, such and such property to the new buyer. So that form, that direction to the trustee needs to be in writing. We want to make sure that we have complete description of the property, complete description and indication of who the buyer is, and obviously instructing the trustee to transfer the property to the new buyer. That's the first piece of document we need before anything else gets done. Step 2, now that the trustee has received this direction from the beneficiary, then we're going to need a deed. The next steps are pretty much the same thing as you would have to do in a normal transaction. In order to transfer the property from the current owner to the next owner, we're going to need a deed. We need a grant deed and a sale transfer. In some other states, it's referred to as a warranty deed. California refers to it as a grant deed. However, we need a deed to be prepared. Who signs this deed? Not the beneficiary. Even though the beneficiary has the power to make decisions and is really in control, the person that would sign the deed will be the trustee. However, in a land trust scenario, this trustee, even though is signing, he or she is signing on behalf of the trust with initially getting direction and authorization from the beneficiary to actually execute such a document. After the deed is executed and notarized, you got to record the deed. And obviously in a sale transaction, the escrow company will take care of that. Part of it will send it for recording. When everything is done, escrow is going to wire the proceeds, write a check to the owner, and escrow is going to write a check or wire the funds to the owner of the property that was your land trust. So the check is going to be made out to the name of the land trust. So if you don't have a bank account for this land trust, you're going to have a hard time cashing that particular check or accepting a wire. So you'll have to make sure you go to the bank and you open up a bank account under the name of the land trust. At that point, you could deposit the money into the account. You could purchase a new property under the same land trust, have this sort of planning that was put in place continue on for the next property that you purchase. Now that you know how to remove a property from a land trust the right way, let me ask you this. If you have set up a California Living Trust, are you sure that is all you need within your estate plan? In my next video, I will break down the truth behind a common misconception. If I have a living trust, do I still need a will? You might be surprised, but what your trust does not cover and why families without a will still end up in court. Don't let a missing piece undo your entire estate plan. Click over now and learn what a real California estate plan should include before it's too late.